A very good afternoon to the esteemed guests and participants. I, Dipakshi Joshi from Dr. Rajendra Prasad Law Institute, Kumaon University, Nainital, feeling highly honored to welcome you all in this online workshop on the topic Dimensional Issues and Challenges of Intellectual Property Rights. The topic we are addressing today is a fast growing field and has a lot of interest from large number of lawyers, research scholars, academicians, corporates, and students. To throw some light on today's topic, I would like to quote Thomas Jefferson here. He who receives an idea from me receives instruction himself without lessening mine, as he who lights his taper at night receives light without darkening me. Now, I would humbly request Professor Atipan Sir, Dean and Head, Faculty of Law, Kumaon University, Nainital, to present the welcome address. Sir, please.
Thank you. Very good morning, afternoon. I would like to take this privilege to extend a very warm welcome to all the delegates and participants in this online workshop on dimensional issues and challenges of intellectual property rights organized by Dr. Rajendra Prasad Law Institute, Kumaon University, Nainital. We are honored this afternoon by the presence of Professor N.K. Joshi, Honorable Vice Chancellor, Kumaon University, Nainital. I am grateful to you finding time to be with us despite your tight schedule. I welcome you, sir, from the core of my heart. It gives me immense pleasure to welcome Professor Raman Mittal, Professor in Charge, Campus Law Center, University of Delhi. Professor Mittal is a scholar of international repute. He has extensive exposure in the areas of intellectual property and cyber laws. He will be enlightening us on today's theme, that is dimensional issues and challenges of intellectual property rights. I extend very warm welcome to you, sir. I have another speaker this afternoon, Professor S. C. Roy, Dean, Research and Development and Director, Center for Innovation, Research and Facilitation in Intellectual Property for Humanity and Development, Chanakya National Law University, Patna. He is internationally renowned and has very rich experience in creating awareness about the economic, social, and cultural benefits of intellectual property rights. I heartily welcome you, sir. I also welcome my senior colleague, Professor S. D. Sharma, Director, Dr. Rajendra Prasad Law Institute, Professor D. K. Bhatt, former Dean, Faculty of Law, Kumaon University, SSJ Campus, Almora, Professor J. S. Bisht, Professor A. K. Naveen, my junior colleagues at SSJ Campus, Almora, my colleagues at Dr. Rajendra Prasad Law Institute, Nainital, students, participants, and Mr. Ravin Bist for his technical support. The National Intellectual Property Rights Policy very aptly states that the 21st century belongs to the knowledge era and this and is driven by knowledge economy. Coming decades are very, very crucial for India. The decision taken by Indian government yesterday to ban 59 Chinese apps has necessitated indigenous inventions and is a clarion call for creative India, innovative India. That is Rasnatmak Bharat, Abhinav Bharat. Recent inventions from hand-free door openers to basic ventilators during COVID-19 pandemic have proved that necessity is the mother of invention and every invention needs IPR protection for being marketable financial asset. Our government has launched various schemes like Make in India, startups, MSME, etc. And it advocates vocal for local. Thus, this is the high time to discuss dimensional issues and challenges of India IPRs. I hope this workshop will be able to boost the local business ecosystem at the same time protecting public interest and traditional wisdoms. Thank you.
Thank you, sir. Thank you so much for giving a perfect start to this program. Am I audible? I am profusely elated to invite Honorable Vice Chancellor, Kumaon University, Professor N.K. Joshi, sir, the man of distinct vision and the fountainhead of illuminating ideas, an idol of knowledge and experience and inspiration to all of us. The topic of today's workshop has also been suggested by him. Your words of wisdom have always enlightened us and have strengthened our steps. I request Professor S.D. Sharma sir, Director Dr. Rajendra Prasad Law Institute, to kindly present the message of Honorable Vice Chancellor Professor N.K. Joshi sir. Sir, please.
Good afternoon to all the participants, resource persons from Delhi University, Professor Raman Mittalji, Professor S.C. Roy from National Law University, Patna, and the organizing team, Director Technical Support, Dean Faculty of Law, Professor A.K. Pant, and former Dean, Professor D.K. Bhatji, our senior colleagues of Faculty of Law, Kumaon University, including Professor J.S. Best and Professor A.K. Naveen, Dr. D.P. Yadav, Arshad Hussain ji, Dr. Dalip Lal ji, and the other participants, students of Kumaon University, National Law University, and other universities, and esteemed guests from different corner of India. The Vice Chancellor had sent the message early in the morning that to communicate my message and good wishes to all the participants, including the organizing team, as he has said that I have to know that Dr. Rajendra Prasad Law Institute, Kumaon University in Nainital, is organizing a workshop on dimensional issues and challenges of intellectual property rights. My best wishes to the all participants of the workshop and welcome to resource person Professor Raman Mittal, Professor in charge of Delhi University, Professor S.C. Rai, Dean, National Law University, Chanakya, Professor S.D. Sharma, Professor A.K. Pant, Dean and Head, Faculty of Law, Kumaon University, Professor D.K. Bhatt, former Dean, and all faculty members of the Kumaon University. Whole organizing team, including the Director Technical Support, Mr. Ravi S. Bist, and my congratulations to all the team and deserve to be commended for organizing such a wonderful workshop. I extend my best wishes for the success of the one day online workshop. This is the message of Honorable Vice Chancellor. This is the message, and he has conveyed the thanks to all.
Thank you, sir. Thank you so much for always motivating and initiating such programs. Now it's time for theme introduction. I humbly request Professor S.D. Sharma sir, Director Dr. Rajendra Prasad Law Institute, Kumaon University, Nainital, and the organizing director of this workshop to kindly throw some light on today's theme, dimensional issues and challenges of intellectual property rights. Sir, please.
Again, on my personal behalf, good afternoon to all the participants, resource persons, technical support director Ravi Vistji, Professor A.K. Panji, Professor D.K. Bhattji, and senior colleagues of the Faculty of Law, Kumaon University, including J.S. Best, A.K. Naveen, D.P. Yadav, Arshad Hussain, Puran Boraji, and Dalveer Lalji, to all the other faculty members of the Dr. Rajendra Prasad Law Institute, including Dr. Deepakshi Joshi and Dr. Suresh Chandra Pandey. Today's seminar is one of the unique in the sense that we are living at present in a digital system of the world society, and therefore a topic which has suggested by Honorable Vice Chancellor of Kumaon University to organize and to invite the resource person from the reputed university. I thought that Professor Raman Mittal is one of the person who have the capacity to highlight on the basic challenges, issues, and new dimensions of intellectual property. He is working on the intellectual property from the inception. In the same way, another expert is Professor S.C. Roy. He has done his PhD on the intellectual property rights. He has initiated the academic work in the National Law University, Patna, by establishing a directorate and the department. Both the resource persons are very unique. They have the expertise knowledge. And the participants in this seminar are from every corner of India, including the Jammu Kashmir and the Raipur, Lucknow, Hyderabad, Tirupati, Bhopal, Ahmedabad, Muradabad, Sarsa, Guwahati, Rajkot, Azamgarh, BHU Banaras, DU Delhi, and Jaspur, Chennai, Gangtok, Patna, Meerut, Noida, Gorakhpur, Sonipat, Dehradun, Jaipur, Shahjahanpur, Pune, and again Tirupati, and then Kanpur, Anantnagpur, then Calcutta, Nalbari, Assam, Unnao, Bijnor, and from every corner, Hosangabad, Pondicherry, Ghaziabad, so many, Simla, and the Roorkee, then again the Khatima, or from every corner, they are the participants. More than 500 participants are participating in this unique kind of the international topic, and thus I will start my today's presentation as a theme with the words of Kalidas. What the Kalidas said about the Asya Uttar Dishayam Disi Devta Himalo Nam Nagadi Raja. We are organizing this seminar in a place as we have organized in 2005 also as a intellectual property rights of the people of intellectual society in Almora, and it is a land of those persons who has contributed the lot about the development of the country by their creative activity. Therefore, it is a Himalayan range. It is a land of Sumitranand Pant. It is a land of the Ilachand Joshi, who were the very famous creative writer, creative poet, not only in India but in the global scenario of the society. Thus, my observation about the system of the today's seminar relating to the issues which has emerged from the international society. Professor John Rawls rightly said that society is more or less self-sufficient. Because why self-sufficient? It is a association of persons who is their natural relation recognized as a binding certain rules of conduct specifying a system of cooperation. Principles of social justice are necessary for making the choice between various available systems. Why the individual is the basically the self-intestate? Because if he has created some new invention, he want to protect it and by interference of others. That's why John Rawls quotation is up to the mark in this sense. And Grotius and Blackstone said, who invents the new things, and first he has the right to retain it as a property. Therefore it is a intellectual property. It is a property which cannot be seen by anyone. There are the two kinds of the property. One is related to the industrial rights property, another is the copyrights property. Therefore there is a system of the protecting the property, and in the property also it requires to follow the ethics, logic, metaphysical, philosophical aspect of the property. Then the duty of everyone is not to interfere, not to infringe the any rights of the persons as he has created by own wisdom, by own intelligentsia, by own way of the creative ideas. Sukrat also rightly said in this regard, but due to the shortage of time, I will not quote everyone. Thus, one side there is a protection of human rights of the intellectual property as prescribed under the UDHR, as prescribed under the social economic covenants and cultural covenants 1966. And another side there is a statutory law, and that statutory law includes the various aspects, especially after the 1994 when India became the signatory. That's the challenges. What are the main challenges? This is the basic today's topic. The challenges, our expert will clear all these challenges, because Professor Raman Mittal is one of the famous expert in this area, and he is leading not only the India, but he is giving the guidance to the intellectual workers and the intellectual persons globally. I hope that he will take the much time. And what are the main challenges as a theme? The challenges are related to the piracy of intellectual property, which is going on in the international scenario as a fashion. As a fashion, cut and policy, cut and paste policy is going on. This is one challenge. Another is new branches are going to be developed. For example, the digital aspect. Some rules has framed in 2017, and then it includes the broadcasting, it includes the telecasting, it includes the internet, it includes the website, and it includes the cyber space. And insufficient regulation, because time to time after 1994, 99, 2000, 2002, and continuously it is going on. But even if there is some issue relating to the insufficiency of regulation, because some infringement of the intellectual property rights are criminal as well as the civil, but some are only the civil. There is no remedy for that. Then lack of awareness in respect of IPR in India, there is a lot of the lack of awareness. No one is aware about the intellectual property rights. The persons, only those persons are aware who are working in the commercial field. They may be the businessmen, they may be using the trademark, and they may be, but farmers' right, it is codified. But the farmers are not aware about their rights also. Therefore, lack of the awareness is another challenge, and lack of the efficient application of the control of the regulation. This is continuously coming on because of this international website access of the internet. Everyone is near to each one, and this can be only solved by those regulations which have the power to competent legislature. Our the expert will focus on these points. Therefore, I am in full confidence that they will not start from only the get agreement. They will not start from the WIPO. They will not go on only of this WPPT, WCT, and other areas of the TRIPS agreement, but they will practically solve the issue which the public at present is facing. The industries are very much aware about their rights, but the intellectual mass who are working in the academic field, they are not aware about this system. Therefore, what mechanism shall be developed in the future? Some other aspects are also there to avoid this infringement of this intellectual property right. One is the industrial right, another, as I have pointed out, the copyright. To advise Indian IP right expert first of all to take the advice of all these things. But there are 20 and some more than that. I will not take much time because we are eager to listen our expert, especially Professor Mittal, because Professor Subhas is facing some problem to join this webinar or workshop. Therefore, my request is not only 40 minutes we are allotting or we are requesting to our esteemed expert, whatever time he will take, we will very much interest to hear Professor Mittal. Thank you very much once again. Welcome to all and every participants from every corner. He may be professor, he may be academician, he may be social worker, he may be student, and he may be the industrialist, or he may be a government employee, he may be another person, media person. Welcome to all in this special kind of webinar, because we are getting this opportunity to listen to our esteemed expert in this area who is sitting in Delhi, where at present there is a problem, but he is expressing the views within this every corner of the global society, not in India. Thank you very much, sir, and we are grateful we have joined us, and our participants will benefit it by your expertise knowledge. Thank you.
Thank you, sir, for the brief and valuable introduction of the topic. I deem it a great honor and privilege to introduce our speaker, Professor Raman Mittal, sir, Dean, Faculty of Law, University of Delhi, an eminent scholar and academician with specialization in intellectual property laws, law of contract, and cyber law. Authored and edited various books in the field of IPR, competition law, international law, copyright and trademark, cyber laws, law of contract, family law, legal aid, and many more. There is a long list of research papers published in various international and national journals. He has delivered lectures to the officials of judicial services at Delhi Judicial Academy and also the officials of public administration time to time. He has undertaken various research projects and thereby contributed in the policy making of the central government. He was also the member of the drafting committee who drafted the Copyright Rules 2012, a research project of HRD Ministry. He has also undertaken the research project granted by the Max Planck Institute of Intellectual Property and Competition Law, Munich, Germany. He is the member of Licensing Executive Society International. It is indeed a very proud moment for all of us. We are delighted to have you among us, sir. We thank you for your kind presence there. Now I humbly request you, sir, to share his views on the topic of this virtual workshop.
Okay, thank you very much. And Honorable Professor N.K. Joshi, Vice Chancellor, Professor A.K. Pant, Professor S.C. Roy, Professor D.K. Bhatt, Professor S.D. Sharma, Mr. Ravindra Bisht, Dr. Dipakshi Joshi, and Dr. Suresh Pandey. It is a really proud privilege for me to be able to address the gathering here. And for that, I would like to start my presentation. And with your permission, let me proceed to share the screen.
Sir, please.
Okay, is the screen visible to you now with my presentation?
No.
Is the screen visible?
No, not right now.
Not really.
No.
Now?
Now, yeah, it's visible, sir. It's visible.
It's visible. Okay,
Yeah.
if I make it full screen, just tell me if it is visible now. Is it visible?
Yes, sir. Yes, sir.
Okay, so I would like to speak on the topic of the day, that is dimensional issues and challenges of intellectual property rights. So I'm really grateful to you, to the organizers, for inviting me to this webinar. Okay, so we'll be talking about intellectual property. We'll be particularly talking about the origin, development, scope, and relevance of intellectual property. Now, I'll start with a question. If we have three circles with us, one circle is known as law, the other is known as property, and the third one is known as intellectual property. How would you like to draw all these three circles so that the relationship between these three concepts becomes clear? So just try for a moment. And according to me, the relationship is something like this. Law is the widest circle, within which is a smaller circle called property, and within which there's a still smaller circle called intellectual property. Now this relationship I wanted to draw in the very beginning so as to make things in the right perspective. Okay, so this is the kind of nature that man encountered when man first stepped on the planet Earth. He must have been something like this. I want all of us to imagine what would have been the life like in those days. We all can imagine, and we can learn from one of the greatest jurists at that time. The first question before him, before man, was preservation. He somehow wanted to preserve himself. And then, after he had secured the preservation, he moved towards pleasure and then towards power. This has been the journey of mankind. And what was the life like that at that time? In the words of Thomas Hobbes, life at that time was isolated, poor, nasty, brutish, and short. Do we really agree? Was it isolated? Yes. Was it poor? Yes, poor in the sense that the gadgets that we have today, the kind of things that we have today were not available at that time. Nasty and brutish, really. Nasty and brutish because all the skeletons that we have found from those days gone by, the age of those persons were not more than 40 to 45 years. That means once the man was past his peak, nature did not at that time permit him to survive. Therefore, it was short. So man wanted to change everything. So how did man change? Man changed it by making law. So there we come to the origin of law. Now, what was the first law? I would like to ask a question or pose a question to the audience. What was the first law that was made by man? If we all agree that we as human beings are the masters of our law, we made our own law and we still make our own law for ourselves, then we must have started somewhere. There must have been some law with which we had started. What was that first law? So this question has mesmerized the jurists over millennia. Various philosophers have opined on this. What is our take on it? I would like to quote here one of the greatest jurists of all times, Jeremy Bentham. In his book on laws and morals, he writes, he tries to respond to this question indirectly. What he says is, law and property were born together and they die together. Now, this small statement, we can find answers to some of the questions, some of the fundamental questions. I repeat his statement. He said, law and property are born together and they die together. What does this mean? Law and property are born together. That means he wanted to say property was the first law that was made by man, and they died together. That means property would be the last law to be disbanded by man. So man is the creator of law, and the first law to be created by mankind was property law. This shows how dear property is to us. And at the same time, he said that property would be the last law to survive. When law is disintegrating, property will be the last one to go. So that shows the importance of property, and that really shows the importance of intellectual property, because which is one of the latest additions to the kitty of property. Now the next question is that I have posed is, when did we make the first law? When we agree that we are the makers of a law, then we must have started somewhere. We must have started sometime. What was that time? So we say that law is responsive in nature. That means it is a response to some problem, some challenge that is encountered by mankind. Now, what was the challenge? The challenge was that there must have been so many quarrels. For example, let me pose another question here. Suppose there was a man at that time, a man like Mr. A, who is apparent here. He was hungry. He got hold of a rabbit. He ran fast, got hold of a rabbit, killed it, and was about to eat it up. That somebody else, another man, came by and snatched the rabbit from this man, Mr. A. Mr. B came and he tried to snatch the rabbit from him. Now the question is, the rabbit belongs to whom? The dispute must have arisen like that. So the answer, what is the answer? What is your answer? According to nature, the rabbit belongs to B, because he has been able to snatch it away from A. Might is right for nature. So what would happen? There would have been a fight between A and B, in which either both of them would be injured, or one of them could be injured, or one of them could have died also, right? A could have been fatally injured too. So we wanted to avoid it. One day we thought enough of it. So we wanted a journey towards lawmaking, and we made a norm that because A has expended labor and he had the skill to catch rabbits, therefore the rabbit must belong to him. Well, there's a counter argument by B also. B says, well, if he had the capacity, the capability to catch a rabbit, I have the capability, I have the skill, I have the talent to snatch away the rabbit from A. Why are you protecting A's talent and not mine? But then that is the choice that law had to make. And somewhere back, law made that choice, that rabbit belonged to A. So this is the progenitor of all property law. And the question is again extremely relevant in the domain of intellectual property, which we shall be seeing. Now, next question is, why did we make the first law? After having seen what was the first law and when did we make the first law, why did we make the first law? Precisely to avoid conflicts and to resolve conflicts and disputes. Okay, so let us now talk about the origin and development of intellectual property. Today, intellectual property contains patents, trademarks, copyrights, designs, confidential information, etc., etc. Now, all these tools of intellectual property had separate origin. This generalization, this clubbing of all these tools into the domain of intellectual property is a later generalization. So we may say that historically, Kalidas was a poet in the reign of legendary king Vikramaditya. Vikramaditya, the history says, had Navaratnas, the famous nine, in his court. He had employed those nine scholars, those nine great persons who were adept in various arts and sciences in his court. Now, what was the reason behind it? So, in those days, scholarships were given to those people who were great creators. Similarly, we say Ashok also followed, Akbar also followed. He had Navaratnas in his court. So, why was this? This was to give, this was a way to give. Royal scholarships was a way to give patronage to the creative artists and scientists. So, the old kings of history have given way to the new kings of business and laws. Now the things have changed. The artists and scientists are made to fend for themselves in the market. In this regard, tracing the history, especially of copyright, I would like to state one old case that arose in 12th century in Scotland during the reign of King Dermot. So there was a pastor who was living in Scotland. His name was, he was living in Scotland during the reign of King Dermot. So he had written down a book of church instructions, which he was using. One day, the pastor's friend visited him. He saw the book and he wanted to borrow the book, to which Saint Columba readily agreed. Saint Columba lent the book to his friend. The friend took the book with him. And in those days, there was no printing press. So there was no photocopiers. So he just copied the whole book in his hand on piece of papers, right? So, and returned the book after a week. And the friend started using the book himself, the copy of the book. Now, Saint Columba could not take it kindly. So he asked his friend to stop it and return the copy of the book to him. The friend refused. Saint Columba took the matter to the court of King Dermot. Now, King Dermot had a unique problem because there was nothing like copyright law written at that time. There was no concept of copyright law, I mean, in the written form or in the form in which we have it today. So, in order to solve this problem and decide this case, he drew an analogy. He gave an example of a cow. He said, let us imagine that Saint Columba had a cow and his friend was visiting and he wanted to borrow the cow. And Saint Columba had lent his cow to his friend. When the cow was with a friend, the cow gave birth to a calf. Now the king framed the question. He said, my question is, the calf belongs to whom? So after framing the question, the king himself sought to answer this question. He said, the calf belongs to the cow. And because the cow belongs to Saint Columba, the calf must also belong to Saint Columba, and ordered. And in the same way, he said, the copy of a book is like the baby of a book. And if the book belongs to Saint Columba, the copy of it must also belong to Saint Columba, and ordered his friend to return the copy to Saint Columba. So we see that at those times, there was nothing like written copyright law, but it was always there in the consciousness of mankind. Today, if we have to decide the same case, we would precisely decide in the same manner. That gives legitimacy to the theories of copyright law. Then we have, if we see the domain of copyright, the first statutory expression, copyright, found in 1710 during the reign of Queen Anne. What was the problem at that time? Because printing press, Gutenberg invented printing press in Germany, and it took about 100 or 200 years for the printing press to become popular around Europe. So when printing press was there, then what happened? Any book that was printed and brought to the market, anybody could buy the book from the market, start printing it at his own place with the help of printing press, and then start marketing the book. And thereby he would be in competition with the first publisher and author. Therefore, authors and publishers, they approached the queen and said that this is patently unfair. The Queen agreed and enacted the first copyright law, that the first statutory expression of copyright law, which is known as the Statute of Anne in 1710. Later on, copyright law developed and found its statutory expression became more and more mature. Similar is the story of other forms of intellectual property laws. So, I would here like to give certain examples of the genesis of these laws. What is copyright all about? Copyright, I say, is creativity. Creativity is seminal to mankind. Man has always been creative and will always be creative. Even when we go to thousands of years old caves, man was painting there. We see paintings. So man must have been composing music thousands of years back. But one day, at that time there was no need of copyright law. But one day, when technology came by and technology met with human creativity, we needed copyright laws. That is what happened when printing press came by. Printing press was the first technology that intersected with human creativity. And at that juncture, we required copyright law. And as and when newer technologies came by and are coming by and impacting our creative processes, we have had to shift our copyright law. We have had to amend our copyright laws, and the copyright law grew with technology. Therefore, copyright is known as the child of technology. It has grown with technology and keeps on growing with technology. As the technology advances, so does copyright. Then we come to trademark laws. Let us imagine a situation. There was a supplier A in the market. Let us suppose he was selling cloths. He was selling garments. And he was the only supplier in the market. And he was selling it to consumers. When there was only one supplier in a market to all the consumers, there was no need of any trademark law. But one day, supplier B came by in the market. He joined the market. He also started selling garments. Now the consumers did not know supplier B. So what he did was, he named himself as A. He masqueraded himself as A. He adopted the name of A because A was already familiar with the consumers. And consumers were familiar with A. So when we did it for the first time, we required trademark law. So the whole growth of trademark law started to support B. To check B, to support A and the consumer. That is the genesis of trademark law. And here, many times a fundamental question is asked, whether trademark law is a property protection law, whether trademark law is a property law or a consumer protection law. Well, the jurists around the world, the philosophers of trademark law, the experts of trademark law, they are equally divided. Some feel that it is a property protection law, and the others feel that it is consumer protection law. The world is equally divided. Why it is property protection? Because it is all apparent. We feel that this trademark law was meant to help the supplier A, and supplier A has proprietary interests in his property because B was trying to adopt A's name and A's style. So trademark law stopped him. So it goes to help A. But if we look behind it, we can also say that ultimately law wanted to help the consumer, because consumer was not empowered enough to pursue against B. He had no means of knowing that B is masquerading against A. So law gave rights to supplier A so that A could stop B, which ultimately helps the consumer. So that school of thought says that trademark law is actually consumer protection law. So this is the genesis of trademark law. And the third very important tool of intellectual property is trade secrets. So we, as human beings, are used to keeping secrets. Secrets is something that we love. We have been keeping secrets under the category of castes. We have been keeping secrets under language which we would not teach others. Communities have kept secrets. Even countries like China kept secret the method of making silk for hundreds of years. And we have known about esoteric groups. Today, because secrets are so important, we recognize trade secrets as a tool of, as a form of intellectual property like copyright, trademark, and patents. So trade secrets are extremely important. And patents, whatever man makes, of course, whatever man executes and makes something, that is protectable under patents as long as it is an invention and conforms to the ideas or the concepts of novelty and inventive step, which we shall discuss later. So all intellectual property now is the second part of my presentation that begins. Idea, we say, is the progenitor of all intellectual property. Idea is very important. What all can we do with idea? Intellectual property is concerned with ideas. Not ideas directly, but when ideas are transformed into certain things. How can we transform an idea? In what ways can we transform an idea? First, if we are seized with an idea, we can express it. We can write it down or express it in whatever ways. And law says if your expression is original, it is protected under copyright law. The second is, for example, now let me give an example here. Mr. A looks at the beauty of sunrise in the early morning, composes a poem in 2010 in English language on the beauty of sunrise. So in this case, who owns copyright? We will give copyright to A. Now what happens? 5 years later, Mr. B, when he was looking at sunrise, he also happened to compose a poem. Now by chance, the poem comes to be exactly the same as that of A. But B has not copied from A, that is a fact. B is able to prove it, that he has not copied it. He has written it himself. So the question here is, would we grant copyright to B? Well, the requirement of law is originality. If we would say, if B's work is original, then law would grant him copyright. So in this case, the poems may be exactly the same, but both A and B can be accommodated with copyright, provided B, has the later comer, has not copied it from the earlier one. That is the law. Now what else can we do with our idea? We can execute, we can make something with an idea. So if our execution is new, then we can get patent on it, because the paramount condition of patent is newness. Now if we transpose the same example into patent setting, for example, A comes up with an idea to make a machine. He makes a machine, or he makes a medicine. Let us say he comes up with an idea to make a medicine and makes a medicine. And the medicine is absolutely new. We would grant him patent. 2 years later, B comes up with the same idea without copying from A. He absolutely didn't know about A's invention. He created it all by himself. He invented it all by himself. Would we grant him patent? The answer is no, because the requirement of patent law is different from the requirement of copyright law. The requirement here is newness. So as long as B is not new, we have to deny any patent rights to him. The third is in the domain of what else can we do with our idea? We can name an idea. If we are seized with an idea, for example, I want to do business in garments. So I give the name to that idea as X. So if X is distinctive, trademark law says if X is distinctive, different from the idea, then that can be given trademark protection. The last one is, what else can we do with our idea? We can keep it to ourselves. And if we keep it to ourselves, that means keep it secret, and we make positive efforts to keep it secret, then we have the protection of trade secret laws. So this is the basics of all intellectual property, the four most important intellectual property rights: copyright, patents, trademark, and trade secrets. This is how idea gets converted into intellectual property through the means of expression, execution, identification, and keeping it secret. Now, what is the relevance of intellectual property? Let's turn into a little bit of jurisprudence. We would talk about natural rights theory, the theory of personhood, and utilitarian theory of Mill and Bentham. First, Locke's theory of appropriation. Locke said, nature was created for all. All means all human beings to share. It is a common to all. We each own our body and the labor it produces. Mixing labor with the common yields a valid property claim. So the theory of John Locke was that if we do our labor, expend our labor to the common things, that common thing becomes our property, but with a rider. This theory had a rider. The rider was that no man, in his own words, he said, no man but he can have a right to what his labor is once joined to, at least where there is enough and as good left in common for others. So John Locke was for property claim, provided the commons are not left poorer, provided the person who claims for property leaves as much for others as was available to them before he made such a claim. So this is extremely important for intellectual property theories that we are going to discuss in the later part of my presentation today. Then we see the personhood and self-realization theory of Hegel. He said that to become fully self-realized, an individual must be able to project his will onto objects in the external world. This requires a stable set of claims over those objects, that is property rights. So we can equationalize his theory by saying that if there is an individual and he exerts his will on an external object, that exertion of will create a stable claim of property, and once a person has a claim of property, his personhood is discovered. This he termed as self-realization. Now we come to the utilitarian perspective of Bentham and Mill. Bentham's famous statement, the greatest good for greatest number of people, that is the yardstick to judge the veracity, the authenticity of all the laws. Similarly, we have to judge the veracity of intellectual property laws today with this theory of greatest good to the greatest number of people and find out for ourselves whether intellectual property laws do conform to this theory or not. Mill argued, John Stuart Mill argued that the moral worth of actions is to be judged in terms of their consequences. He was for a cost-benefit analysis through an economic lens. He said rights follow only from calculations of collective welfare. That means the greatest good to the greatest number of people. And he also said that natural rights are bullshit on the stilts. So they were positivists. So we try to apply those theories. If a person is there and we say that we give him property claim for his effort so that he becomes rich and is able to fend for himself. Now we take the example of J.K. Rowling, one of the greatest authors of our times. So John Locke would say, she worked hard in drawing from a long tradition of wizard and coming of age tales, and so deserves copyright in her Harry Potter books. Hegel would say, the writing of those books literally helped make her who she actually is, or helped her more fully realize who she really is. Therefore, we must grant her copyright. And Bentham would say, if we give a guarantee of future copyright to her, she will be encouraged to create more and more. So we see different jurisprudential theories coming together in the application to intellectual property rights. So in the current century, intellectual property is under constant strain. We have various goals to pursue. We have the goals of education. We want more and more people to be educated, consumer protection, food security, public health, entertainment, human rights, development, national sovereignty. So all these goals, a particular law, for example, intellectual property law, is expected to enhance all these social goals. Is it really possible? Well, if we enhance one, the other may be sacrificed. So what we are trying to do is, by pulling and pressurizing, we are trying to create a situation of a balance, which is extremely difficult, we say. Now, IP skepticism. With this, I would like to just briefly mention about IP skepticism also. Why should one person have the exclusive right to possess and use something which all people could possess and use concurrently? That is a fundamental question. Intellectual property, by granting intellectual property, we say that something belongs exclusively to the owner of intellectual property. So when the same thing can be enjoyed by all, why are we restricting it? Stealing a physical object involves depriving someone of the object taken, whereas taking an intellectual property deprives the owner neither of possession nor of the use of that object. For example, if I have a car, how many persons can I invite in the car? Maybe four more persons, or 5 more persons, or 6, maybe depending upon the size of the car. But if I have a book, say a digital book, how many people can I invite to read the book? Limitless. So the skepticism of intellectual property says that when it is physically possible to distribute intellectual property to all, why do we have such laws? So there is a point in this theory also, which we shall discuss. Intellectual property, they say, needlessly give higher prices to consumers. And further argument for this skepticism is that new inventions are always dependent on some extent or existing knowledge. Even one of the greatest scientists that the world has ever known, Isaac Newton, is known to have commented that if I have seen further than others, it is because I have been standing on the shoulders of giants. So he acknowledged those scientists who came before him. So this theory says that why do we grant intellectual property at all when the creative activity is dependent upon the previously created works, right? So we have to be mindful of these theories when we come to deciding complex questions of law. Now, I would also like to highlight the interface between human rights and intellectual property rights. Article 27 of UDHR, Universal Declaration of Human Rights, Part 1 says that everyone has the right to freely to participate in the cultural life of the community, to enjoy the arts, and to share in scientific advancement and its benefits. So what does it mean if we apply this to intellectual property? That means everybody has a right to share in the scientific advancement, in the creative activity. And second says, everyone has the right to protection of moral and material interests resulting from any scientific, literary, or artistic production of which he is the author. So the two parts of Article 19, they seem to be cutting across each other. One emphasizes on the rights of the public to share in everything. If there is a new medicine, everybody should have the right to share it. And the same breath, point 2 says that if somebody has created a medicine or something else, then he should have exclusive right on that so that he can earn money out of it. He can recover his investment. So I would say that these two are seemingly opposite to each other, but they are not actually opposites. They may seem to be opposites. They are just tools to balance, to create a right balance for intellectual property. What is the extent of ownership? To what extent ownership can go? To what limit ownership can be put to? And how we can increase sharing. So if we are able to draw that balance, then I think we are able to achieve the objective of intellectual property too. So in these days, there has been a debate on private interest and public interest. Private interest versus public interest is one of the famous and most important topics of intellectual property law today. So if we draw a circle like this and call it public interest, where would you like to draw private interest? This is a question to you. So I cannot wait for the answer to you, otherwise it would have been more interesting, because there could be many renditions of this, but I would like to state what I feel. I feel that private interest lies within public interest, because public interest is all encompassing, includes everybody and one private individual. Normally, this is in intellectual property, we say that private interest belongs to the interest of the owner of intellectual property, and public interest belongs to the consumers of intellectual property, right? So with this, I would like to proceed. Now, first, I would like to draw your attention to patent laws. We have, in the last few years, we have seen three very important cases. First has been Natco versus Bayer Corporation, in which a compulsory license, the first and only compulsory license granted by India, was there. Then Roche versus Cipla and Novartis versus Union of India. Now, what happened in this case? In these all three cases, the common ground was a multinational company on the one side, which had come up with a blockbuster, a very great medicine, and it was priced very high. In Indian context, it was priced, say, for example, for a month's dosage, you require a couple of lakh rupees. So the question arose in this country, how many people can actually afford such medicines? What is the relevance of these medicine in Indian parlance, right? Therefore, the courts were proactive, and what they did was applying the various doctrines of law, for example, applying compulsory licensing and interpretation of Section 3D of the Patents Act, the court declined them their patent rights, the three multinational companies. Now, this created a great uproar in the international market, that how can India do it? And it also presents, on the one side, we have a public interest argument on which the court was riding, but we have the other argument as well. So let us see the other argument too, to balance the two. For example, how drugs are made. For example, today the whole world is suffering from COVID-19. We are frantically searching for a drug. Now imagine tomorrow somebody comes up with a drug. Then we will expect him to give the drug. For example, that person keeps a big price for the drug. He says that, well, I have invested so much of money in experiments. I have put everything on this. So I should be allowed to earn money now. Now then, if the whole world comes up and says that, no, we need it and we need it cheap, we cannot allow you to make that much money. So who is right in this situation and who is wrong? If today we say that nobody will be able to earn from COVID-19 vaccine or medicine that comes by, then people may not be encouraged to invest in so much of research, because that is costly, that is time consuming, right? Especially we see that first, in order to cure something, let us take the example of a disease. In order to cure something, in order to make a medicine, we know the disease, but we do not know the medicine. So somebody has to come up with an idea of making the medicine. And then he has to proceed into various directions. So he has to do due diligence and experiments in various ways. And most of the experiments, if the person who is tasked with, taken up the task to invent a medicine, he goes into 20 different paths of creating the medicine. Maybe in 19 he would fail. So all that investment will be lost investment. Only in one he might succeed. So he takes the risk. He does all the experimentation. And after being successful, it goes into the testing phase. First, it has to be tested on in the laboratory. Then it has to be tested on animals. Then it has to be tested on human beings. And then he has to get approvals, including marketing approvals. With all this, once he comes to the market, then a generic manufacturer comes up. He says, well, I can make the medicine cheaper than you. So I would say that generic manufacturer, he had ready-made everything with himself. He did not make an investment in any of the above aspects. So he will of course be cheaper than the person who has been able to invent it. So, and then there are other tools. For example, tools of compulsory license that we have seen, tool of infringement and counterclaim. He can infringe his patent and counterclaim that the patent itself was invalid. So we say that on the one hand, we have seen multinational companies fleecing the poor countries. Multinational companies, even in pharmaceuticals, they are pricing exorbitantly. But at the same time, even the generic manufacturers are also doing some kind of cheating by just picking up the inventions by some other persons. So we have to really, who is right in this situation? Law should side with whom? That is a fundamental question of intellectual property law. And there is no one answer to this. So the idea here is to just let us all work together to find answers to such perplexing questions. Let us turn to the domain of copyright now. We had the famous Delhi University photocopy case in which we also had a chance to participate. So what happened? What was happening in Delhi University in brief? That there were course packs, something like this. Now, for example, in the course of MA of Economics, the teachers have prescribed 10 different books, and the students are required to read 2 or 3 chapters from each book. Now, it is just not possible, and some of those books are foreign books and they're very costly books, and it is not possible for students to buy 10 costly books for one subject, and they have to study many subjects. So what was happening in Delhi University was that there was a photocopy shop inside Delhi School of Economics. We are just taking the example of economics, but the same is applicable elsewhere as well. So he would note that what the professors have prescribed. So he would photocopy those very chapters from different books and make course packs. And those course packs, then he would photocopy. For example, he knows there are so many students in MA course and all of them would come to buy those course packs. He would make them already before the session starts, and it was very easy. It was practical and affordable for the student. So a 300-page course pack would cost something like 200 rupees. So this was happening. So the publishers filed a suit for copyright infringement, saying that the photocopy guy and Delhi University have infringed the copyright of those publishers. So the issue was, we know section 14 of Copyright Act exhaustively lists various rights, and section 52 grants those exceptions to rights. It's fair dealing exceptions. So the question before the court was whether the making of course packs by Delhi University photocopy shop falls within 14 or within 52. If it falls within 52, then of course it is not a wrong. It is not copyright infringement. But it falls into the white portion of 14, then of course it is copyright infringement. And that is what precisely the case was, right? Now, section 52(1)(I) of the Copyright Act, which is about fair dealing, it says a fair dealing in reproduction of any work by a teacher or pupil in the course of instruction. So all that we had to demonstrate before the court was that these course packs are covered within this expression, the reproduction of any work by a teacher or pupil in the course of instruction, So at the outset, we drew this chart and presented it to the court. We said that the exemption is only through the expression course of instruction. Now, course of instruction is comprised of 2 words, instruction and course. Instruction means teaching and education. And course, this word course can be used as a noun as well as a verb. Now, if we use it as a noun, course of instruction means a program. Like, kaun sa course kar rahe ho? And the person says MA Economics or LLB. That is also the meaning of the word course when it is used as a noun. It means program of education or teaching like MA or BA or LLB. Now, in this case, we argued that our law permits reproduction in the entire program of education, for example, a semester, or the full course of MA, for example, 2 years. When the legal phrase is the reproduction of any work by a teacher or pupil in the course of instruction, right? So the course of instruction would be like 2 years of MA or 3 years of BA. So that is all permitted. Well, that is the widest possible interpretation of the word. But then we also highlighted another interpretation, that is verb. If we consider course as a verb, it becomes a process. That means process of education or teaching. Now this process in this sense is capable of being interpreted in 2 ways. One is a narrow interpretation. That means the course means reproduction is permissible only in classroom when the teaching is taking place. And we highlighted that is not possible. The classrooms do not have photocopiers. And second is, even in the verb sense, when we take course as a verb, it accommodates a wider interpretation, which means reproduction is permissible in the entire span of the course, right? During the entire span of the course. So we demonstrated to the court that this expression course of instruction There are two wider interpretations possible and one narrow. And the narrow interpretation is totally impractical. So if we choose wider interpretation, then the practice of photocopying that is going on in Delhi University becomes legal. And the court, the High Court of Delhi, sided with us completely and agreed with us. All right. Therefore, the new jurisprudence in copyright law emerged, and this is a very path-breaking case. And because we have a paucity of time, so I wanted to discuss parallel importation, so I skipped that. And or please let me know how much time do I have.
So we have 10 minutes more.
How much?
10 minutes more because we have another speaker as well.
Yeah, okay, so okay. All right. So I won't like to impinge on his time, so I like to finish early. And I would like to say, state here the saying of a great jurist Plato. He said, "For are not money and virtue like the two scales of a balance? As one goes up, the other goes down." Aristotle regarded the institution of property as indestructible and ultimately a positive force. Aristotle based his opposition to common ownership on utilitarian grounds. He was of the opinion that if we remove all property from the society, then no one takes proper care of the objects that are not his. We have all the right to go to the public park, but we do not take care of public park as much as we take care of our own house. So people who hold things in common tend to pearl more than those who own them personally. That was also the opinion of Aristotle. Hesiod, the Greek poet of 7th century BC, he was also of the opinion that he favored common ownership, but at the same time, he saw various difficulties. Now we see Lenin, on the other hand, he is known to have said, private property is robbery, and a state based on private property is a state of robbers who fight to share in the spoils. Do we really agree? Saint Augustine of Hippo had said that propertyless society can exist only in heaven. That means it is a common aspiration to do away with property. But have we been able to do away with property? So I would like to take you back to our thesis of property. What was said by the philosophers long time back, that law and property are born together and they die together. This is what Bentham had said. So property is very dear and it continues to be dear. So intellectual property is dear too, and extremely dear and extremely important for the society. We see we need more and more inventions, and it is the property nature of knowledge that induces creative activity. So intellectual property is good, but at the same time, it is good when a proper balance is maintained. It should not be too proprietary in nature. It should also be sharing. The element of sharing should always be there along with property. So as long as we are able to make a balance, it will be good for all. So has there ever been a period where there was no property? It is difficult to say so. There has never been a period. The vision of an ideal property-less world must be grounded not in collective memory, but in collective longing. So propertylessness has to pass through. If we want to achieve a state of where there is no property, we have to pass through property first. So in the end, I would like to quote from the poem of Lao Tzu, one of the greatest mystics. So he's believed to have said, stretch a bow to the very full, and you will wish you had stopped in time. Temper a sword to its very sharpest, and the edge will not last long. So all he says is that if you stretch the law of intellectual property to the extreme, then it will break. And if we sharpen the sword of intellectual property too much, then its edge will itself break. So he's also pointing towards a balance. So we all are discovering that balance. Our lawmaking processes, our judicial interpretations are all geared towards achieving that right balance. So thank you so much. And it was a great pleasure to be able to speak to you. Thank you very much. Over to you, ma'am.
Unmuting. Thank you, sir. Thank you so much for such an informative and rich session. We are getting an overwhelming response from the viewers' side. And now, it is often said that when we appreciate excellence, we make it the part of our own. I feel privileged to welcome our esteemed speaker, multi-talented and immensely intellectual luminary, Professor S.C. Roy, Dean Research and Development, Chanakya National Law University, Patna. Sir is also the Director, Center for Innovation, Research and Facilitation in Intellectual Property for Humanity and Development. He has teaching experience of about 23 years. His areas of interest are jurisprudence, criminology, labor law, corporate law, intellectual property law, insurance law, legal research methodology, human rights, sociology of law, and English literature. He has credit of about 65 papers, research papers being published in renowned national and international journals. He has authored and edited many books. Some of them are An Analytical Study of Intellectual Property Rights in India, Lectures on Intellectual Property Law, and Intellectual Property Rights, A Prismatic View, Working of Patents, Law and Pharmaceutical Implications, Information Security, Law and Governance. He has participated and presented papers in more than 100 national and international seminars and workshops. He has chaired many sessions of the national seminars and also organized various seminars, symposiums, and workshops at CNLU. He has served as member of various academic and administrative committees and also held the responsibility of academic and research coordinator of CNLU from July 2009 to March 2017. He has addressed judicial officers, insurance trainees, entrepreneurs, NGOs, trainees of disaster management, and participants of orientation program. He had been visiting professor cum resource person in Judicial Academy Patna, NIPER Hazipur, Rajendra Agricultural University Pusa, BIPARD Valmi Patna, NIRDA Patna, and UGC ASC Lucknow University. He is on the editorial board of A Journal of Asia for Democracy and Development, a national journal of comparative law. He is the life member of Indian Institute of Insurance, Mumbai, Indian Society of Criminology, Chennai, Indian Society of Labor Economics, Associate Member of Indian Institute of Public Administration, New Delhi, All India Teachers Educators, All India Law Teachers Congress, Indian Council of Arbitration, New Delhi, UGC Academic Staff College, Nainital. He is also the member of Asian Society of International Law. Sir, we are keenly awaiting for the session and the audience is all yours, sir.
Thank you, ma'am. Am I visible? Am I visible and audible?
Sir, you are audible, but visibility is not there.
How to connect? How to connect? Because which button should I click? Share screen.
No, it's camera. Camera is on.
Camera is on. Yes. Camera is on. Camera is on.
Okay. Please, sir, is there, I think there is a technical problem.
Yeah. I am calling my colleague. He will do it.
Ravi, sir, please.
Camera is on, but it is not working. Just a minute.
Yes, sir.
Camera is on. How to StreamYard powered by? It is not Just a minute, I am calling. Okay, I'll start and I will call someone. It is not visible.
Yes, the voice is audible, but it is clear, but not the. I think the camera is not working properly.
Your camera is not working. Okay, let us start. Someone will come, I have asked.
Okay.
Professor Roy, you may reconnect, please.
Yeah?
You may reconnect. First of all, disconnect it and reconnect. And after connecting, just allow your camera and mic accept.
Okay, let us, then I will have to call first.
You just leave the studio and then again enter into the studio.
Okay, I am calling.
There is a red button.
Yeah. I should leave
Yes,
studio.
Leave and
studio,
then
and
reconnect.
then again re-enter.
Yeah. Am
Yes,
I
sir. You are
visible?
visible now.
Now
Okay.
it's visible.
Okay.
Namaskar.
Yeah, namaskar. अच्छा ये है. Okay. Namaskar. Welcome you, Madam Vipakshi Joshi.
Thank you.
Sir,
कर लीजिए
my
प्लीज. कैमरा थोड़ा सा नीचे. कैमरे को थोड़ा सा नीचे.
reference. Hello.
कैमरे को थोड़ा सा एडजस्ट नीचे को कर लीजिए. हाँ, थोड़ा सा स्लाइड डाउन कर लीजिए प्लीज.
अब ठीक है. ओके सर. एस डी शर्मा साहब को प्रणाम. डी के भट्ट सर को मेरा नमस्कार. सर, thanks in the very beginning that you have given me opportunity, and Dipakshi ma'am also. Sir, from where Professor Raman Mittal has left our discussion, I will start from there, as the topic of this workshop is dimensional issues and challenges of intellectual property rights. We are fortunate to one person, I think that Dunkel, as in the Uruguay round of GATT, Dunkel's proposal was in news, and because of Dunkel's proposal in Uruguay round of GATT, we could know about intellectual property rights. Before that, very few of us were knowing what intellectual property is. Think that later on we know very well that from 1st January 1995, the GATT, before that in the April 1994, GATT concluded into TRIPS, trade related intellectual property rights, and from 1st January 1995 we have WTO, World Trade Organization. And on the ground of GATT, TRIPS, all the signatory countries, they were developing and least developed countries, they were given 15 years, 10 years moratorium period that they can change their IPR laws. Although India had IPR laws from the very beginning, and we have Patents Act 1970. Before that, so we are not new in intellectual property rights laws, but because of the TRIPS agreement, we brought changes. In patents law, we moved from process patent to product patent. Earlier we had, before 1970, we had a product patent. But in 1970 Amendment Act, we changed from, we omitted product patents, but later on again in 2005, we amended and it added in the Patents Act 1970. And then we know very well that we have new legislations, Plant Varieties, Farmers' Rights Act, sui generis legislation. Sui generis in the sense that it suits to a particular country. A special law, you can say. Although TRIPS agreement says that the country should have minimum standard. Minimum protection must be there. Why there should be protection? It's a subject matter of discussion also in this workshop. As earlier Professor Raman Mittal had said that property is common, but those who have invented the property, created the property, might have certain interest. If that person is not protected, not encouraged monetarily, not given impetus, encouragement, he will not further create, he will not further innovate. Therefore, in this sense, he has to encourage for what purposes? For the benefit of the society, maximum good of the society. As when a person writes a literature under the Copyright Act, he creates something for the better understanding, mental development, educational development of humanity. Therefore, for that purposes, there is a protection to that author, to that creator. At the same time, in the patents, a person who is inventing something, he is giving labor, skill and judgment, and in this way, he invests his time, mind and energy, and naturally, if there is a certain asset intellectually after the idea is invested and created, asset, then he is the owner of that property. He must be given protection. Otherwise, he will not be encouraged and new things will not come in the society, in the market, and people will not be benefited. So encouragement, protection is given for encouragement. It is not prohibitory, as there was a talk in the copyright section 52. It gives relief. It gives that the exemption is there on section 14 of the Copyright Act, that yes, the person owner has the right, economic rights in the creation, but at the same time that creation is for the public purposes, not for economic exploitation, rather for educational purposes and other purposes. Other dimensions are there. But we see that and in the same way in the patents law also, as NATCO case sir has mentioned, Professor Raman Mittal, that that there is a provision that lakhs of rupees for a month package of medicine it was not beneficial. So one thing is that there is a public purposes also in patents law, that if the patent is not working properly, then the government will not remain silent. The government can seize that property, as we have in that general property law also. As earlier we had fundamental rights under Article 19(1)(f) of the Constitution, right to property, but later on it has been deleted and put into Article 300(a) of the Constitution. Although many people say that that right is a very strong right to property, but it can be said that it is not a fundamental right. It was earlier a fundamental right protected by Chapter 3rd of the Constitution under Article 32, but it is not now under Article 32. So property, yes, of course, the person who has created that property has interest, but at the same time, for whom this property is there? For the public interest. And this is why under TRIPS agreement, there is a rights for 20 years. After that, it enters into public domain and anyone can use that idea, use that invention, creation, everything. So let us see that since we are living in this age of information and knowledge, and this is a global era, and we can understand very well now because of the pandemic situation that how we have been suffering. How are we now disconnected from the world because of the COVID-19? So therefore, we can understand in a better way about the globalization, information technology and information services. So in this respect, we will see, and in the very beginning, I would like to say that after the TRIPS agreement, after making amendments in our IP laws and legislation of new laws also, Biodiversity Act, Geographical Indications and Protection Acts, Registration and Protection Acts, likewise Plant Varieties and Farmers' Rights Act, as well as Semiconductor Acts, Layout Design and Semiconductors Act, so many legislations, Industrial Designs Act 2000, we have legislated, we have made our laws strong, but it was still beyond the reach of the common people. And this is why the government of India in 2016 brought a paper, new IPR policy in 2016. 7 points have been framed in that new IPR policy, and that is, first point, IPR awareness, outreach and promotion. IPR awareness program, it is a very, very significant program. That why the government of India took this first point, awareness, lack of awareness. Still many people are not knowing what is IPR, intellectual property rights. As earlier speaker, Professor Mittal rightly said that property, it's a broader concept, and within that there is intellectual property. Although in our Indian constitution, we will see that there is no such clear cut in the, suppose even in a 300A, capital A, there is no mentioning of intellectual property. So as per in America, there is a mentioning of Article 1, Section 8, that there is an intellectual property. Here it is not mentioned. So that's why when it is not clearly mentioned in the articles of the Constitution of India, how can people be aware of these things? Second awareness is that still people were aware of the patents. Many things we are calling about patents. It is his patents, means monopoly. People think about patent means monopoly, means ekadhikar, that he has rights, he can do everything. But it is not so. Even the Patents Act 1970 is not a monopolistic rights, because it has rights to the people, other people also. So second thing is awareness related to even the school. People are not knowing about the intellectual property. It is not mentioned in the course curriculum. So awareness, when it is not generated common to the students, to the people, then how can we can we understand, groom, and do research and do everything. Second objective is that generation of IPR, that is to stimulate the generation of IPR. Generation of IPR means creation of IPR. First, there should be awareness creation. Secondly, there should be encouragement to generate and to create. It is the thing that IP audit across the sectors will enable assessment and evaluation of the potential in specific sectors. Generation of the intellectual property. Property will be generated later on. First, there will be generation or creation of awareness and encouragement to the people to do something. Bring your ideas or dream into concrete asset. So, generation, and third concept is legal and legislative framework, that IPR laws has to be legislated, enacted in such a balanced way that it should be in favor of beneficial to the interest of the individual, as well as it should be beneficial to the common people, public at large also. Fourth policy is administration and management, to modernize and strengthen service-oriented IPR administration. This is the fourth policy. Fifth policy is commercialization of IPR. As I was delivering a lecture in A.N. Sinha College, Patna, on A.N. Sinha Memorial Lecture, here one student asked me, "Sir, I have a hobby of painting, drawing, sketching. So where shall I sell these things?" This is a problem. People are not knowing, even if they are creating something, they are not in a position to commercialize, earn money. So commercialization. Sixth is enforcement and adjudication. And in enforcement and adjudication, minimization of litigation is essential. If there is a true litigation, so many litigations, then litigation cost is added to the intellectual property asset, and ultimately the common people has to pay, and it is very costly. This is why litigation should be minimum, and this is why arbitration was given encouragement, has been given encouragement for the solution of the problems or the disputes related to IPR. And the seventh and the most important that is the policy is the human capital development. As we see that human capital development, what does it mean? It says that expand human resources. As generally we have heard about the human resource development, as our HRD ministry is known as. What are the human resources? Education, knowledge, attitude, aptitude, our behaviors, intelligence. These things are the human resources, and we have to develop. So intellectual property as copyright, it is essential, as without the books, without literature in any discipline, unless and until it is created, unless and it is authored, there can be no teaching, there can be no development, mental development, there can be no physical, behavioral development and human development. So that's why human capital development is the objective, ultimate objective of this policy. But I would like to say now that this is a policy paper. Whether the policy paper has been brought into practice, yes, of course, some changes has been brought up. DIPP, Department of Intellectual Property and Promotion, has been created. Copyright, patents, and so many things has been brought there. And Ministry of Industry has been assigned all these things, that you develop all these things. But see, what are the issues and challenges? As the title of the dimensional issues and challenges of intellectual property rights, this is the topic of the workshop. Dimensional issues are so many. As we see, as Professor Mittal said, photocopier case. Yes, of course, it was in favor of the students. Naturally, it should be, it ought to be. But what about the authors? Whether their claim was not correct? we have to think properly. At the same time now, because of the COVID challenge, now everything is going on online, and now software is being produced. Software. So here in India, software is protected under the Copyright Act, because we say that software is nothing but expression. But if it is taken as a functional one, it should not be protected under copyright. It should be protected under patents. As here people are demanding that software should be protected under the patents law. But it has not been amended under the Indian IP legislation, patents law 1970. It is still under the copyright law. This is the issue, that whether, and there is a debate going on, that software should be patented or copyrighted, or partly patented or partly copyrighted. It should not be there, because two things at a time is not possible. There should be either copyright or patent, but strong, as the policy measure says, strong legislation to protect the interest of the creators and the authors, it is essential. So software protection, as we all know that nowadays it is vulnerable and pirated softwares are being sold. The creators are at loss, great loss. Second is that, you know that nowadays online movie, online music, this is going on. Now downloading of these things, as well as without payment of any money. So 3D piracy is also an issue and challenge nowadays. How to check these menaces and how to provide protection to the creator, producer, author of these. So next is that in the patents law, we talk about that patents every time, but we seldom know that what is patents. Actually, when a person invents something new, novel, non-obvious or inventive steps and useful industrially, then the person is granted rights that is known as patents. So earlier in Britain, it was a letter patentia, means open letter. Whoever was disclosing his invention was granted patents rights. That is patents. Rights to the inventor is known as patents. Through open letter, through disclosure of the authority. Here in India, as per a TRIPS agreement, we have 20 years time period, whoever is granted patents. But see, what is our situation? We have a great challenge in our country. Today we have a situation, we have started avoiding Chinese goods or many other things. We have problems with China, our neighbor. We are talking about how to stop Chinese import, Chinese goods to enter into Indian territory, and we should not use it. Our Honorable Prime Minister has also indirectly said, Swami Atmanirbhar Bharat. Before that, this COVID announcement, Atmanirbhar Bharat, before that, the government of India has started Make in India program, Innovative India, Creative India program. So all these programs have been started, have been launched. Even in this very nearest in COVID period, the government of India has given the slogan, vocal for local. All these things are there. One may ask me that why I am talking all these things. What is connection with this patents law or intellectual property rights? Yes, of course, there is a connection. Even the policy paper of 2016 of IPR, the word is that Creative India, Innovative India. Yes, is it merely a slogan? It's not merely a slogan. We will have to go back. If you see that the intellectual property, industrial property as patents, it took root in or genesis in Paris Convention of 1883. Later on, you see that we have a patent, but in 1979 there was a amendment in Paris Convention, and utility model was introduced in Paris Convention. Although we see that under TRIPS model, utility model or petty patent has not been introduced. So, and India is the signatory to this Paris Convention. About 46 countries of the world and more than that, and of Paris Convention, 130 countries are the signatory to the Paris Convention, and they are somehow and directly or indirectly they are adopting petty patent policy. See that if we are saying that we can become Atmanirbhar, self-dependent, we can boost up our Make in India, Made in India program successful through MSME, micro, small and medium enterprises. Can we do with the help of patents only? Because patents require heavy investment. It requires time to be granted also. It requires heavy capital for protection also. Can the MSME afford that money? Not possible. China has been successful in doing that, petty patent. One application, two patents. This is the Chinese slogan. Whereas in India and the UK and USA also, I would like to talk about India, that one application, one patent. It is our policy, and as per the law also, that one application will be granted only one patent. Whereas China is granting, if someone has submitted the application and if it is not patentable or if it does not come as per the test or quality of examination, that it is not new or novel, not inventive steps, technological development, then it can be granted utility model or petty patent, or another name is innovation patent. And with the help, and it is granted up to 10 years, not more than that. 7 to 10 years, 12 years in different cases. So, and it is very cheap. It is registered very quickly and people start using those inventions in their small scale industries. Since it is less costly, less time taking, therefore the micro, small and medium enterprises are in a position to thrive, manufacture goods and sell it at lower cost to the neighboring countries or any countries, and they are successful. So if we want to make ourselves Atmanirbhar, then we will have to give boost up to this petty patent. But there has been a debate, negative debate against this petty patent policy. So that's why that in the very beginning I said that in the policy paper, IPR policy 2016, policy is there, but implementation is, we are far behind, and we have a challenge now, Atmanirbhar, how to do that. So innovative patents or innovation patent, you can say, it will be in between the claim of invention as to prior art. Prior art means the knowledge to the people, in between that. So it will be useful for the small scale industries, for the traders, businessmen, for the MSME, and we can create wealth, employment, and we can develop, and we can export also. Economically, we can develop and we can become strong. Our investment will go, earning will go to another areas, and we will be happy. So one challenge is there, but there are so many barriers in this way. Another is one we are knowing very well, that we are living in the age of biotechnology. We are living in this age, and plants and animals and many other things we are extracting, we are making goods. So with the help of biotechnology, we can grow more and more. Biotechnology industry is increasing in increasing order, growing more and more. But whether we have given any recognition, any protection, or any support to the biotechnology industry, we will see that under the Patents Act, the concept section 3, we will see the Patents Act, it talks about which is not patentable. subject matter which is not patentable. There is nothing positive like what are the patentable subject matters. And you will see that many things are mentioned under section 3 which debars even the plants and traditional knowledge. Okay, I am not saying that the traditional knowledge should be exploited by someone else, but at least there should be sharing of the knowledge. So section 3D, it is quite hard one in India. We are not taking care of the discovery. We say invention means invention. It should not be anywhere. No one, no, even none has thought about it. It is not possible. Even USA is giving discovery. They are recognizing, and people are taking benefit of that discovery. What about our situation? We should take care of that. Discovery should be recognized also. So agriculture and horticulture, many things. As you see that nowadays I have heard about Sri Vidhi se dhan ki kheti, paddy farming through Sri Vidhi. When I heard and saw doing the things, planting paddy seedlings, I thought I have seen already. It is already available in our community. See that plant varieties and farmers' right, breeding of the plants, cutting, budding of the plants, seed, as seed rights we have. Farmers are knowing all these things, but they are not aware of how to do these things, how to market these things. So negative rights under section 3 of the Patents Act, it is also a great challenge. It is also a great hindrance in our progress. So another thing is related to electronic goods. As we know very well, electronic goods, that we are living in that electronic goods, our mobile, washing machine, many other things, AC, air conditioner, that printers, computers, they have the small silicon chips. And the chips, you see that it is very, very important. We have Layout Design and Semiconductor Layout Design Act 2000. And you see that here we have legislated one legislation, sui generis legislation. It is protecting. We have followed the USA and the Act of 1984, and along with that we have this legislation. But at the same time, the chips are being pirated also. The scientists or the persons who are skilled in the trade are not in a position to exploit. So chips is also, semiconductor and layout design is also very, very important and significant part of this IPR regime. And we have to protect these chips. See that, so that we can develop our industry, businesses, electronic businesses. And this is why National Institute of Electronics has been established by the government of India under Ministry of Electronics. And here in Patna also, one NILET, National Institute of Electronics and Telecommunication is here established. There is an institute. So we see that electronics chips, it is also a subject matter of a challenge before us. Now another part, that is the geographical indications, biodiversity and plant varieties and farmers' rights, that one can be said. Plant variety, when one can exclude biodiversity, geographical indications, you see this is nothing but a community property. It cannot be individual property. But geographical indications, it is ownership lies to the people of the area, not any individual one. And it is one of the most important aspects of the trade. And so GIE, it is most important. We should preserve, but awareness is lacking. As I can cite an example, that when I went to Kerala in Cochin University, I was in a program. I was handed over one packet of rice. It was called Palakkad rice. Palakkad rice, when I came back to Patna and cooked it, the taste was same as in Bihar. There was lal dhan, lal paddy, rice was a red one, and it had the same taste. But see that the people of that area saved that rice, traditional rice, and now they are growing and they are exploiting. They are selling that rice in the market, and the cost is 150 rupees per kg. So whether we could have saved the traditional seeds, as people nowadays talk about that nowadays there is no taste in medicine, taste in vegetables, taste in rice, taste in wheat. Nowadays we have modified seeds, genetic seeds. It's a challenge. We need food security. We need to grow more grain, but at the same time we are losing the traditional varieties. Here, if we can save or could have saved the traditional varieties, we can grow and sell them also, and we can be in a position to make new varieties, new seeds, new things also. So geographical indications, as you see, artisans, special, many people have their special qualities, special regions, as Kanjivaram silk, Varanasi silk, Bhagalpuri silk, as in Raipur also there is a silk cloths, they are being manufactured. So many artisans are there. As our Prime Minister says, vocal for local. Unless and until there is a petty patents, unless and until there is innovation patent, we cannot become vocal for local. Only by saying we cannot do that, unless we are granted certain rights. And in this way, if this patent is granted to the people, naturally the people will be happy and there will be encouragement to the local innovation. Of course, it can be locally granted. It cannot be recognized nationally or universally, otherwise it will fall under patents law. So innovation patent is a demand of today. It's an issue as well as challenge also. So what we see that entire IPR, either it be copyright, it be patents, trademark, as in trademark also there is a comparative advertisement. It is issue and challenge. That why there is a query and concern of the people, the traders, that if Mr. A is advertising his mustard oil that it is pure, why Mr. A is taking name of B that it is better than A, better than B? So you must develop your own trade, your advertisement of your own goods in a way that it should be used by the people, and the people will come to you themselves, and in this way you will grow. Let others grow also. So comparative advertisement is an issue in the trademark. So in this way, the workshop title as a issues and challenges are the various one. Now we are coming across with these issues, but there is a yet to solution. So patent solution, that is the innovation patent, it is must, it is essential. We must immediately we should take care of, and other things related to copyright, software patenting. These are the issues, these are the challenges before us. Thank you. Hello.
Yes, sir.
Hello.
Yes, sir. Am I audible?
Yeah.
Thank you, sir. Thank you for the insightful lecture on the topic. I heartily thank our dignitaries that they have created time out of their tight schedules to add value to Kumaon University's conscientious efforts at pushing academic frontiers in a way that can benefit our society during this time. And we are now opening the floor for the questions. And participants, if you have any questions, you may send through chat box. Now, I have sent some questions in the chat box to Professor Mittal.
Okay, so all right. So Okay, how much time do we have?
Sir, we have 15-20 minutes more.
Okay.
Okay, all right. So I'll try and dispose of quickly. So the first question is, what are parallel importing with respect to copyright? So basically, parallel importation is a very important area under intellectual property law, under all spheres of intellectual property law, whether it's copyright, trademark, patents, etc. So let me address it with regard to copyright. See, what exactly is parallel importation? Parallel importation means that there is an official channel. For example, in case of books, Oxford University Press, let us say, has a distributor in India, and the press is there in UK, and the books are printed in UK and brought to India through the official channel. Now, can somebody go to, for example, another country, say UK, and buy Oxford University books, for example, from the UK market and bring them to India and start selling without any authorization from Oxford University Press? So this is precisely what is meant by parallel importation. This is important from trademark law perspective also, and we had a very famous case, that is Samsung versus Kapil Wadhwa. And for example, in that case, somebody goes to Singapore and buys printers, computer printers, and brings them to India. For example, he buys 1,000 printers from the open market in Singapore, brings them to India and starts selling. And those Samsung printers are already available in India through the official channel of Samsung. So the private person who does so, who goes to Singapore and brings those printers, his activity is known as parallel importation. So we are like, the law is quite interesting and challenging as far as parallel importation in copyright as well as trademark is concerned. Let me address the issue of trademark first. This case went into trademark and in the courts, and we had a different opinion. First was the single judge of Delhi High Court. He decided that parallel importation is not possible under Trademarks Act. So he termed this practice as illegal under Trademarks Act. Then it was appealed to the division bench. The division bench said that parallel importation is legal. The division bench read the same law and decided that the law is permissive. That is Section 30 of Trademarks Act. Section 30, subsection 3 of Trademarks Act is permissive of parallel importation. Then the case was now appealed, and the appeal is pending before the Supreme Court of India. So a livelihood of and a lot of business is dependent upon what the Supreme Court, what the Apex Court of India will decide finally with regard to parallel importation vis-a-vis Trademarks Act. And turning to copyright law now vis-a-vis parallel importation, you have rightly stated that a provision was sought to be incorporated by way of 2012 amendments, which are the most recent amendments to the Copyright Act. That is right. The thing is that we do not have much judicial guidance with respect to parallel importation. As far as copyright law is concerned, we have all along, we had a penguin case long back, many, I think at least 2 or 3 decades back. In this case, in Penguin's case, parallel importation was stated to be illegal under copyright law. And just to do away with the decision of the Penguin, the effect of Penguin's case, the copyright law was amended. And it was amended, and now in section 14.8.2, it says that 14.8.2 is something which says that the right of the owner to issue copies of a work to the public, not being copies already in circulation. Not being copies already in circulation, this expression holds the key as to whether the practice of parallel importation is legal or not legal in India. And what happened after this amendment, what happened in 2012? And between that, there was another case, John Willis case, which was decided by Delhi High Court. And that case, that decision has been criticized a lot, in which we can say the court held that parallel importation is not permissible within the Copyright Act. But then that the decision did not match the facts of the case. It was not a correct interpretation of law. Therefore, the law was thought to be changed again, though there was no need. And it was thought to be changed, but because there was an uproar by foreign publishers' lobby, so this proposed amendment was taken off the bill. When the bill was finally introduced in the parliament, it did not have the explanation to infringing copy, right? To the definition of infringing copy, through which this law of parallel importation was sought to be reformed. But in my understanding, if we interpret section 14 in the light of the whole act, I find that parallel importation is permissible, irrespective of what has been decided. Whatever has been decided, it is possible, and it is legal. And in trademark law, it is legal as far as the division bench's decision is concerned, but it is pending before the Supreme Court of India. So in a nutshell, we say the law of the land today is the division bench decision, and it says parallel importation is legal in case of trademark law. In copyright law, it is yet to be decided by the court. What happened? We wrongly say that in 2010, in John Willis case, it was decided. It was not decided because the matter there was parallel exports, not imports. So the court said that the activity was illegal, but that activity was parallel exports. So we can't say that John Willis case of 2010 is enumerative of parallel importation in India. It is an open question. And my understanding is parallel importation is legal. Okay, then what else is the question? Let me see.
Yesterday's order under section 69A of IT Act.
They say what is the difference between blocking and this banning. So block is more technical in nature, though the distinction is not so well defined, but blocking is more technical, more technological, and banning is more legal. So normally when the government does so, it does so on both the counts. It bans through law, through order, through direction, and it also stops the technical feasibility of it. All right. So that's what I can say. Is there any other question?
Sir, Suresh,
I see a question on damages, right? So as we say, how are IPR infringement damages calculated? So we all know that damages are of various kinds, with various orientation. We have compensatory damages, we have general and special damages, we have liquidated and unliquidated damages. We have a damages, the measure of which is loss of profit. We have restitutional damages, we have disgorgement damages, we have statutory damages, and we have nominal damages, and more. So see, a lot of theories come into play when the courts calculate damages in intellectual property matters. And one of the most important theories is the restitutional or disgorgement damages. For example, that a person utilizes somebody's intellectual property unauthorizedly, and he is able to earn some profits because of that. So the court can not only issue an injunction, but also grant disgorgement damages. That means the profit which that person, that unauthorized user, has earned because of an infringement of intellectual property can also be discharged. Then loss of profit can also be a measure. The person, if he is because of somebody else, he was not able to use his own property. So had he been able to use the property, he would have been able to earn certain profits. So that can also be a measure. So basically, these theories of tort law are well accommodated within intellectual property damages principles. And I will also say that, for example, in case most of the practice of intellectual property is done through licensing activity. And in case of breach of a license, what the damage it would be. So that would be an interplay of damages because damages is a concept within contract law as well as tort law. So when it is a licensing matter and licensing of intellectual property, every license is a contract, and a breach of license would attract not only damages under contract law, but also damages under tort law as well. So, but at the same time, the principle, the cardinal principle is that in one action, the person should not be allowed to recover double damages. All right. So that is the interplay. And is there any other question?
From Professor Roy. Dr. Suresh Chandra Pandey, over to you. Your voice is not coming. You are not audible.
Yeah, audible. Yes.
Okay. There is a question to Professor Roy.
Yes.
Sir, are people aware of the provisions of the Constitution other than those related to IPR?
Yeah, your question is very marvelous question. Yeah, people are aware of Constitution more than IPR, of course. But as in the beginning, your question is related to that, as I said, that it is not mentioned in the Constitution of India, as in the American Constitution. Actually, even suppose it had been mentioned in the property under 300A or earlier under 191F, it could have, people could have taken notice. Because constitution is a basic, tenet of our country, and people could have thought about that, yes, this is intellectual property and it is mentioned here and what it is. But actually it is not mentioned. So this is why I am drawing the attention that it should have been mentioned along with the property. Intellectual property should have been also. Although we are taking, our legislations are not unauthorized, it is under the Schedule 7, and out of that we are making legislations, IPR legislations. But specifically there is no such article, and had it been there, I am sure that people would have been more aware of these kind of IPR. And I am frankly saying that it is Dunkel's proposal that brought revolution in the world. Before that, how many people of us were knowing about all these things? And even in a teaching academia before 2000, people were not knowing about intellectual property. When I took this, this research work in TM Bhagalpur University, I am the student of Bhagalpur University, and when I said there that I want to do research in intellectual property, people were surprised. What are you saying? Who will guide you? And frankly, I am telling you that I would like to tell name Honorable Professor Kiran Saxena. She guided me. She told me, yes, I will guide you. And she learned and did hard work, and she guided me. Although I took support from various people, various professors, and one is among them Professor S.D. Sarma sir also. I took his help also. I am grateful to you, sir. And I took suggestion and help from Professor S.K. Verma of Delhi University. At that time, she was in ILI, director also, and she helped me. So I took help from various people from different parts of the country, and then I could do the work on IPR. So I know the thing that how many people were knowing about the intellectual property. And see that intellectual property and rights, as rightly Professor Mittal delivered in the very beginning, the jurisprudential concept. When I teach in the class, in the very few classes, I discuss the jurisprudential aspect, that proper intellect, property, and then rights. Three things, it takes 4 or 5 classes. Then it is clear that what property is and the concept of property. So these things are there, and distributive justice also related to, as Kamesar Singh versus State of Bihar. That case is very significant related to property, and it is also relevant to this intellectual property also, because private interest versus public interest, as rightly Professor Mittal discussed earlier, that private interest has to forego when there is a public interest. As rightly it has been said, when Article 39 B and C comes, Article 14 and 19 goes out. So when there is a social, benefit, economic and social justice, then private justice has to be minimized. So all these things, all these aspects are, it's a very, very interesting paper, interesting subject, and it is connected with jurisprudence as well as constitution, as well as economic theory and social justice theory. So it cannot be taken in isolation. If someone is saying that I am teaching copyright law, it is not isolated. One has to be connected, interconnected. If someone is going to teach GIE, geographical indications, the person has to have understand trademark also. If someone is going to teach plant varieties and farmers' rights, it means he has to understand agricultural knowledge as well as agricultural laws also. So many things are there. In totality, we have to learn and we have to disseminate. And this is my very, very small sharing of the knowledge, what I have learned till today. So that's why, sir, constitutional provision should be there, and it will be create more and more awareness among the people. Sir, anything more? Any other question?
I need a common. I'm giving that a common question to both of you. Well,
Yes.
how can IP law be simplified for the awareness of common people?
Okay. Pardon me
How can
again.
IP law be simplified for the awareness of common people? Common man, I mean.
You know,
Sir,
awareness. You know, I am telling you that I have established a center in Patna. Objective is that, and this CIPP as well as in the Ministry of Industry, it is also trying to, and CIPM. CIPM has been established by the central government. Primary function is to create awareness program. Although they are not funding, but they are giving academic support, resource person support, and for the dissemination of the IPR knowledge to the common people. It requires to move village to village, school to school. In the primary sector, it requires to go to enter into the village, tell the people what is IPR, intellectual property, and what are your property. I see the traditional knowledge. People have the traditional knowledge about so many herbs, medicines. I am sharing one example. My uncle was in a village, as we know very well, jaundice. हम जानते हैं jaundice पीलिया बीमारी. In jaundice, doctors prohibit you
yes,
to
sir.
take any spices. मसाले नहीं खाना है, अदरक नहीं खाना है, गोल मिर्च नहीं खाना है जॉन्डिस में. लेकिन वो हमारे एक अंकल थे, यदि किसी को जॉन्डिस होती थी तो कहीं से एक रूट उखाड़ कर लाते थे, कोई रूट, एंड दैट रूट हैज टू बी पेस्टेड विथ गोल मिर्च. काली मिर्च के साथ वो रूट पीस करके 14 डेज देते थे एंड द पर्सन वाज क्योर्ड. तो मैंने सुना उस समय आई वाज द स्टूडेंट ऑफ क्लास 8-9. सो आई आस्क्ड हिम, अंकल दिस spice is harmful to the person who is suffering from jaundice. You are putting these things, but he told, I am not knowing many things, but I am immersing this medicine, introducing this medicine, and person is cured. So many people are knowing about the medicines, herbs. Can it be commercialized? As you see that in Uti, the people are using certain oil. They use it in their body and they are free from mosquitoes in the remote areas. So this knowledge can be commercialized. Many things we are knowing, it should be commercialized. As vermicompost, nowadays it has been commercialized by agriculture sector. Vermicompost is nothing but a compost. Only worms are there. So many worms are there, and I have seen in my villages how people are making the compost in the pit with dung and other leaves and other things, agriculture reduce. So all these things we are knowing, it can be marketed. Geographical indications, many things are specialist. You see that one example I will tell you, futka. Futka, it is not known to everyone. It is when there is a cloud, thunder in the sky during this season, rainy season. It comes after the bursting of the earth. That is like a cauliflower. बंधा गोभी होती है ना, तो बंधा गोभी की तरह वो एक होता है, उसको कहते हैं फुटका. फुटका इसलिए कहते हैं धरती फटकर निकलता है, और वो तब निकलता है जब आकाश में बादल गरजते हैं, और वो झारखंड के हजारीबाग में होता है. That is a special one. No other places it can have. Why not? It can be commercialized, marketed, and the people will be benefited. So that many things are there. We have locally, but we are not using it. जैसे our Prime Minister has said that each area has some specialty. Each area. एक बार मैं महू की यात्रा पर था, महू MHO, जहां आवर भीमराव अम्बेडकर साहब बर्थ प्लेस. तो उस एरिया में एक खंडवा से ट्रेन जाती है. उस रास्ते में एक प्लेस है जो वैली में है, 2 बड़ी बड़ी ऊंची पहाड़ियां हैं, उसके नीचे है वो. और वहां एक मिठाई मिलती है, दैट इज ए स्पेशल स्वीट्स, कैन इट नॉट बी मार्केटेड? अब वहां के लोगों को समझाएंगे कि भाई तुम्हारा ये जीआई है, ये स्पेशलिटी है, इस गुड्स का तुम मार्केटिंग करो, ज्यादा से ज्यादा प्रोडक्शन करो और तुम बेचो और तुम्हें लाभ होगा, बेनिफिट होगा, तो वो लोग होंगे। तो हम लोग जब तक गांव गांव जाकर के लोगों को समझाएंगे नहीं, स्कूल में जाके बच्चों को नहीं समझाएंगे, तो इनोवेट नहीं कर पाएंगे। इसीलिए इनोवेशन पेटेंट और इनोवेशन इज एसेंशियल। आप आत्मनिर्भर भारत बनाना चाहते हैं, जब तक आप पेटी पेटेंट की ओर नहीं जाएंगे जो चाइना गया है, तो तब तक आप नहीं कर पाएंगे। व्हाई नॉट? जब मैं प्रेजेंटेशन दे रहा था सिंगापुर में, तो वहां भी मैंने प्रेजेंटेशन दिया, 1 एप्लीकेशन 3 पेटेंट्स शुड बी हियर। कैसे? लोगों ने पूछा आप कैसे कहते हैं भाई? मैंने कहा चाइना ने कर दिया, चाइना 1 एप्लीकेशन 2 पेटेंट्स। इफ सर्टेन इन्वेंशन इज नॉट पेटेंटेबल, यदि वो बार्ड है, वो इन्वेंटिव स्टेप्स नहीं आ रहा है उसमें, तो वो क्या कर देता है? पेटी पेटेंट दे देता है। आप ले लो पेटी पेटेंट, यानी उसका जो मेहनत है, लेबर स्किल एंड जजमेंट, जो इन्वेस्टमेंट है, बेकार नहीं गया, वो कॉमर्शियल एमएसएमई में काम आ गया। और वही लो कॉस्ट इन्वेंशन नाउ इट इज इन प्रोडक्ट फॉर्म एंड इट इज सेलिंग। आप कहते हैं चाइना से मुकाबला, आप मुकाबला कैसे करेंगे? अनलेस एंड अनटिल यू हैव दिस टेक्नोलॉजी। आपके यहां पेटी पेटेंट पर बैन है, नहीं है, वेहीमेंटली इवन द पार्लियामेंटेरियंस हैव अपोज्ड इट। आप कैसे रोकेंगे? क्या एमएसएमई को है इतनी हिम्मत, इतना कैपिटल है कि वो पेटेंट्स खरीद सके और उसको प्रोटेक्ट भी कर सके? नॉट पॉसिबल। तो हमें डाइल्यूट करना। और भी कंट्रीज हैं, नॉट ओनली चाइना, जापान, अदर कोरिया, 46 कंट्रीज दे आर गिविंग पेटी पेटेंट्स, इनोवेशन पेटेंट्स, एंड दे हैव इन्वॉल्व द स्कूल स्टूडेंट्स आल्सो। छोटे छोटे क्लास 8 से बच्चों को इन्वॉल्व किया है, क्रिएटिविटी में इन्वॉल्व किया है, और जिसके चलते वो उन बच्चों में इनोवेटिव कैपेसिटी आ गई है। और जो इंडस्ट्रियलिस्ट इनोवेट करते हैं वो तो अलग है, एंड दे आर ग्रोइंग, दे आर commercializing all these innovations, all these knowledge, but we are lagging behind. We are only talking, we are not actually doing anything. So we will have to amend our legislations. This is why मैंने जो डिस्कशन किया है यहाँ कि what are the issues and what are the challenges. Issues तो ये सब हैं। अब जैसे सर ने कहा कि कॉपियर ठीक है, लड़के खुश हो गए सर, लेकिन आपकी ही बुक को यदि सर छाप छाप के बेचना शुरू करें तो आपको क्या मिलेगा? What you will get, जो कि आपने लेबर स्किल एंड जजमेंट दिया, आपका जो बुक है बहुत अच्छी बुक है, आई हैव रेड इट। सर ने जो लिखा है मित्तल साहब ने, लेबर ये ट्रेडमार्क पर, बेस्ट बुक। लेकिन उस बुक को यदि ये फोटो कॉपियर बेचना शुरू कर देंगे 200 रुपये में, 100 रुपये में, तो फिर ऑथर का ओरिजिनल बुक क्या होगा? ऑथर को क्या मिलेगा? व्हाट अबाउट द ऑथर, उसको भी देखना है। दूसरा, अभी 3 डायमेंशनल पैरेसी जो हो रही है, उसका क्या होगा? तो वी हैव टू सी बोथ, बैलेंसिंग वन। यही कारण, इसका कारण क्या है? इन्फोर्समेंट मैकेनिज्म इज लैकिंग। आप देखेंगे कि 2000 के पहले साइबर लॉ तो 2000 में है, और साइबर लॉ अभी भी जो इन्फोर्समेंट एजेंसी हमारी है, पुलिस फोर्स, कितने लोगों को पता है? हम लोग स्मार्टफोन यूज करते हैं, लेकिन क्या हम लोगों को मालूम है कि उसमें कितने फीचर हैं और कहां हमारी प्राइवेसी खत्म हो रही है? उसमें आता है कुकी। अब कुकी पर जब तक आप नहीं प्रेस करेंगे तब तक वो ओपन होगा ही नहीं दूसरा, तो आप सारा का सारा इंफॉर्मेशन आपका जा रहा है, डेटा जा रहा है। हम लोग फेसबुक यूज करते हैं धड़ल्ले के साथ, फोटो पोस्ट करते हैं, लिखते हैं, आप देखें क्या वो प्राइवेसी रह जाता है? नहीं रहता है। तो हम लोग अवेयर नहीं है। दिस इज व्हाई अवेयरनेस इज द मोस्ट इंपॉर्टेंट थिंग। अवेयरनेस जनरेट करना, क्रिएट करना बहुत जरूरी है। और आईपीआर का यदि अवेयरनेस क्रिएट किया जाता है इस देश में, अलग अलग जहां जहां जो लोग हैं, तो एक तो इंटेलेक्चुअल डेवलपमेंट होगा। कॉपीराइट प्रोटेक्शन क्यों दिया जाता है कि यू शुड नॉट, अभी जो यूजीसी ने प्लेगियरिज्म की बात की है, व्हाई देयर इज अ चेक ऑन प्लेगियरिज्म? दूसरों का आर्टिकल अपना नाम लिख देते हैं, कहते हैं मेरी आर्टिकल है। एक तो ये हुआ, चोरी करते हैं। दूसरा, ये एकेडमिक थिफ्ट। दूसरी बात ये होती है कि हम लोग क्या करते हैं, कट पेस्ट करके लिख लेते हैं। क्रिएटिविटी नहीं है। क्रिएटिविटी इज एसेंशियल। क्यों क्रिएटिविटी जरूरी है? जस्ट एक एग्जांपल मैं दूंगा मैं कि जैसे ही सेशन शुरू होता है आपका, तो आपके नए बच्चे आते हैं और वो पूछते हैं कि आईपीआर की कौन सी बुक लें, तो हम सजेस्ट करेंगे रमन मित्तल साहब का ले लो, किसी और का ले लो, किसी और का ले लो। इस बुक का मतलब क्या है? किसी सर्टेन ऑथर का ले लो, शर्मा साहब का ले लो, जोशी साहब का ले लो, क्यों ले लो? क्योंकि वो बुक इतना सिंप्लीफाइड वे में है कि बच्चे पढ़ेंगे तो इजी वे में समझ जाएंगे। और वो सिंपल वे में कौन लिख सकता है? वही लिख सकता है who has chewed and digested, assimilated। जैसे हम भोजन करते हैं, चबा करके पेट में डालते हैं और अच्छी तरह से पच जाता है, तब वो हमारा जो छोटी आंत का विलाई है वो एब्जॉर्ब करके ग्लूकोज एंड मिनरल्स एंड प्रोटीन्स जो भी हो हमारे बॉडी को देता है और समूची बॉडी में वो जाता है ब्लड के माध्यम से। वह काम उस टीचर ने किया है, बहुत मेहनत किया है उस टीचर ने, इसीलिए वो बुक अच्छी है, उसमें फ्लो है, कनेक्टिविटी है, मीनिंग है, अदरवाइज बुक अच्छी नहीं हो सकती। बहुत सारी बुक हम देखेंगे मार्केट में, 2-3 पेज पढ़ने के बाद रखो, हटाओ। क्यों? क्योंकि उसमें उतना वर्क नहीं हुआ है। दिस इज वाई कॉपीराइट प्रोटेक्शन, कि आप किसी का लें तो आप एक्नॉलेज करें, आप उनको रेस्पेक्ट दें, एट द सेम टाइम यू मस्ट हैव अ राइट्स। प्रोटेक्शन तो जरूरी है, अदरवाइज लोग काम नहीं करेगा। एक समय था कि लोग दूसरों के लिए कुछ लिखते थे, एरिस्टोटिल हो या आप देखेंगे तुलसीदास जी ने कहा स्वांता सुखाय तुलसी रघुनाथ गाथा, निबंध मात। अपने सुख के लिए उन्होंने रामचरितमानस की रचना की। आज के समय में यदि रामचरितमानस और उनके सक्सेसर्स को कितनी रॉयल्टी मिलेगी आज के समय में? तो वो एक समय था कि दूसरों के सुख के लिए लोगों ने किया। आज लोग ये सोचते हैं कि यदि हम टाइम, माइंड, एनर्जी इन्वेस्ट करते हैं, आई शुड हैव रिटर्न, और इसीलिए कॉपीराइट को दिया लाइफ टाइम प्लस 60 इयर्स। उसके बाद वो पब्लिक डोमेन में जाएगा। पेटेंट्स में दिया 20 इयर्स, लेकिन 20 इयर्स इज टू मच लॉन्ग टाइम। सो देयरफॉर, एंड दूसरा डिमेरिट क्या है कि पेटेंट है नहीं, तो आपकी इंडस्ट्री कहां से ग्रो करेगी? और तीसरा, सर मित्तल साहब शायद ये एग्री करेंगे कि वर्किंग ऑफ पेटेंट्स, 80% पेटेंट हमारे यहाँ शोकेस में रखा हुआ है, वो एक्चुअली इंडस्ट्री में यूज नहीं हो रहा है। सर यू विल एग्री और नॉट? वर्किंग ऑफ द पेटेंट इज नॉट वर्किंग प्रॉपर्ली। मुसीबत ये हो गई है। तो क्या जरूरत है भाई? लो इन्वेस्टमेंट, आप ऐसा करो ना, उसको फ्री दे दो लोगों को, एमएसएमई वाली को ही दे दो। नहीं, वो ना तो देंगे ना हम यूज कर पाएंगे, क्योंकि हैवी इन्वेस्टमेंट इज रिक्वायर्ड। थर्ड, ट्रेड सीक्रेट, व्हाई नॉट? देयर इज अ लॉ ऑन ट्रेड सीक्रेट, सिविल लॉ है, कॉन्ट्रैक्ट एक्ट में प्रोटेक्शन है उसको। 1 एप्लीकेशन 3 पेटेंट, आप उसका भी, ट्रेड सीक्रेट का भी रजिस्ट्रेशन करा दो। यदि इफ अ पर्सन इज नॉट गोइंग टू डिस्क्लोज, तो वो ट्रेड सीक्रेट होगा, एटलीस्ट ही विल बी रजिस्टर्ड। एटलीस्ट यदि पेटेंटेबल नहीं है तो पेटी पेटेंट होगा। देयर विल बी रिवॉल्यूशन इन दिस कंट्री। एंड पब्लिकेशन, देयर शुड बी लार्ज नंबर ऑफ पब्लिकेशंस। अभी आप देखेंगे ये जो यूजीसी ने केयर निकाला है, केयर जर्नल वाला लिस्ट, ये ताज्जुब है। यूजीसी एक और कहता है कि प्लेगरिज्म मत करो, दूसरी ओर कहता है केयर में यदि आपका आर्टिकल पब्लिश होगा तो आपको पॉइंट मिलेगा, प्रमोशन होगा, अदरवाइज यू विल नॉट बी प्रोमोटेड। और हमारे जो बड़े बड़े बुजुर्ग प्रोफेसर्स हैं, क्षमा कीजिएगा सर, गुस्सा मत करेंगे, वो लोग कहते हैं कि तुम्हारा आर्टिकल केयर में पब्लिश नहीं है, सो यू विल नॉट गेट पॉइंट, यू विल नॉट बिकम प्रोफेसर। अभी स्क्रीनिंग में मैं गया था तो मुझे लड़ाई करनी पड़ी और मैंने कहा कि केयर तो आज आया है, इसका आर्टिकल 5 साल पहले पब्लिश हुआ है, साहब आप उसको पॉइंट कैसे नहीं दोगे? और दूसरा, केयर में कितने जर्नल्स हैं, कितने लॉ जर्नल्स हैं जो कि लॉ की आर्टिकल पब्लिश होगी? कौन कौन जाएगा? और एक आदमी आर्टिकल पब्लिश कराने के लिए कितने साल वेट करेगा? वेयर इज एनकरेजमेंट? Yes, you must check plagiarism. You must encourage quality writing. You must encourage creativity. But at the same time, you must provide the opportunity, environment to the people. ये जरूरी है। तभी हमारे intellectual property has a capability to provide, maximum number of people, knowledge and employment. दोनों बातें इसमें है। कॉपीराइट के जरिए हम पर्सनालिटी डेवलप करेंगे, एज ह्यूमन कैपिटल की बात की गई है, 7th पॉलिसी ऑफ द आईपीआर, और पेटेंट्स एंड अदर उसके द्वारा एम्प्लॉयमेंट जनरेट करेंगे, साइंस एंड टेक्नोलॉजी विल डेवलप एंड इंटायर सोसाइटी विल बी हैप्पी इफ रियली देयर इज अ प्रोपेगेशन टीचिंग ऑफ इंटेलेक्चुअल प्रॉपर्टी लॉज एंड राइट्स. Sir, anything?
Sir, Professor Mittal, sir, please throw some light on of awareness.
आवाज कट के आ रही है.
How to, I think, how to generate awareness among people, common man, about this.
That's why मैंने कहा ना कि ये हम लोग जो वर्कशॉप,
Professor Roy has already in great detail mentioned about awareness. I would like to be very brief. The seminar that you have organized goes a long way. Such seminars can go a long way in creating awareness. We need more awareness, right, in practice as well as in theory, in intellectual property. Our commerce, our industry, our literature, our arts are dependent on that. And many times it is mentioned that our arts, for example, the practices of Bollywood, are not very much intellectual property friendly. So we have to do that. On the one hand, that we have to strengthen the payment mechanism to authors, composers, music composers, writers of songs, etc., writers of script, right? And at the same time,
so right main side है, how to propagate,
etc.
how to create
So that has to be there.
Yeah.
All right.
How to create awareness, as we are doing, workshop in the urban areas, we have to do workshop in the village, rural areas. Then people will learn. We have to make a workshop or organize workshop in schools where children are learning in a simple language. In a simple language, in a common language, in a day-to-day language, we have to make them understand. Unless this type of campaign is there can be no awareness. Because we know very well that we are attending these seminars or organizing these seminars. What are the purposes? Very few people are taking benefit. Very few people.
Sir.
Thank you, sir. Thank you.
Okay.
Dr. Suresh Chandra Pandey, I request Dr. Pandey to please propose a vote of thanks on behalf of Dr. Rajendra Prasad Law Institute, Kumaon University, Nainital.
Okay. Thank you so much, ma'am, for giving me an opportunity to propose vote of thanks. It is my great privilege to propose a vote of thanks at this online workshop on dimensional issues and challenges of intellectual property rights, organized by Dr. Rajendra Prasad Law Institute, Kumaon University, Nainital. On behalf of Dr. Rajendra Prasad Law Institute, organizing committee, and my own behalf, I extend a very hearty vote of thanks to all the speakers and participants gracing this online workshop with their presence. First of all, I would like to thank our Honorable Vice Chancellor, His Excellency Professor N.K. Joshi sir, who is presiding this online workshop. Without his blessings and inspiration, this online workshop could not be organized. Thank you very much, sir, for having faith on us and your kind permission to organize this online workshop. Thank you, sir, for your blessings. Thank you, sir, for sparing the time despite having onerous reservations. Thank you so much. After that, I convey my deep sense of regard, gratitude, and thanks to our guest speaker, Professor Raman Mittal, sir, Professor in Charge, Campus Law Center, Delhi University, who has graciously accepted our invitation, consenting to deliver the lecture. We are very fortunate, sir, to listen the views of Professor Raman Mittal, sir. He has explored all the aspects of the topic. Thank you, sir, for sharing your insightful and comprehensive thoughts. Thank you, sir. Thank you so much. We are deeply indebted to our guest speaker, Professor S. C. Roy, the Dean, Research and Development, Director, CIRF in Intellectual Property, Chanakya National Law University, Patna, for graciously accepting our invitation and sharing with us his vision on the subject. Thank you, sir, for your scholarly, lucid, and informative views on the topic of this online workshop. Thank you, sir. Thank you so much. I also like to extend my sincere thanks to Professor A.K. Pant, sir, Dean and Head, Faculty of Law, Kumaon University, for blessing this program with his gracious presence and sharing his views on the subject. Thank you, sir. Thank you so much. I also extend my special thanks to Senior Professor D.K. Bhatt sir, former Dean, Faculty of Law, Kumar University, for blessing this program with his gracious presence. Thank you, sir. Thank you so much. I also like to thank Professor S.D. Sharma sir, who is organizing director of this online workshop, and also the director of Dr. Rajendra Prasad Law Institute, Kumar University, Nainital, for organizing this online workshop on such an important topic. Thank you, sir, for giving the opportunity of being part of this online workshop. Thank you, sir. Thank you so much. I also like to thank to Mr. Ravin Singh Base, sir, Director, Chanakya Law College, Rudrapur, who is head of the technical support team to this online workshop for providing necessary technological support to conduct this workshop. Thank you, sir. Thank you so much. I also thank my senior at Dr. Rajendra Prasad Law Institute, Kumar University, Nainital, Dr. Dipakshi Joshi ma'am, who is also a member of the organizing committee of this online workshop. Thank you so much, ma'am. I also like to thank Pratibha Singh, a student of Dr. Rajendra Prasad Law Institute, Kumar University, Nainital, for assisting by selecting questions of participants for question answer session. I thank the whole organizing team to make this program a success. On behalf of the organizing committee, I convey hearty thanks to all participants from across India. It's clear that you are the foundation behind the success of this online workshop. Thank you so much. And lastly, I would like to thank everyone once again. Thank you so much.